Okay, hey Facebook. My name is Stephanie Haines. I'm with TMJ4, and I'm joined by criminal defense attorney Patrick Cafferty. And I am catching my breath. I had to run over from one corner of the Kenosha County Courthouse into the car to finish up my live shot. I was just telling Patrick we were a bit of the bottom news today because of Rogers testing positive for COVID. But there were still some important things that have happened in court today and over the past few days. So where I left off with you, Pat, was with jury selection. And late on Monday, 7:30ish, they got a jury. I mean, what did you think when you heard that?
I was really surprised that the judge let court go that long. Generally speaking, the last few years, there have been budgetary cuts, and the county executives and supervisors have dictated to the courts that they can't go late because it means overtime for clerks and deputies and so forth. So the judge must have gotten special permission in advance to be able to fund this so that he could get this done. So I was really surprised that they went as late as they did, but it's apparent that the judge wants to be efficient and keep this on track and keep it moving forward.
And one of the things that they did was individual voir dire, which actually I have never seen before. And so they take individual jurors into a room and ask them away from the other pool of jurors. I was not one of the media in there because I was on deadline, but media was allowed to be in there. And what happens in that?
So sometimes they'll take individual jurors into chambers or into a conference room if they're talking about things that may be embarrassing or may reveal information about the individual juror that, frankly, they don't want revealed publicly. So that's what was going on. I don't think they did that with too many potential jurors. They seem to have done it still relatively quickly and sorted through those folks and got it back on track.
And then yesterday, we had opening statements, which were not as long as I expected. I have sat through some that have been more than an hour, and each of them didn't appear close to that. And then, so what do you think of those?
There was a difference in the style that each lawyer took. The prosecutor basically got up, told what he thought the evidence was going to be, really didn't use any exhibits or video. And then the complete opposite of that was the defense lawyer, who got up and basically told his story start to finish by using the exhibits that are ultimately going to be part of the trial, including the video, to show the jury what he thought the evidence was going to show. So we'll see at the end of the case, but we have a concept called primacy and recency, or two concepts. Primacy is basically what people hear first is oftentimes what they remember, or what they hear last is what they will remember. So the first thing that they're probably going to remember are the videos that were shown by the defense, and the defense showed them in the order that they wanted and put their spin on those videos. So that may be effective at the end of the case when jurors are asked, hey, how did you make this decision? They may go back to that opening statement in the video that they were shown. Now, on the other hand, it'll be 2 weeks before they make a decision, or 10 days, whatever it's going to be. And by the time they get to it, it may be that they remember the last thing they've heard as opposed to the first thing they've heard. So it was interesting to see the contrast in styles, though.
Have you seen either one of these attorneys give opening statements before? Did it sound like them, or their own styles?
Yeah, I have not seen either of them previously give opening statements, but both of them were appropriate and likely effective for what they were trying to accomplish. But at the end of the day, the judge is giving instructions to the jury, basically saying, hey, these are just statements or opinions by the lawyers. This really isn't evidence. Wait until the actual evidence comes in before you make up your mind. So I mean, there's a whole lot these jurors are going to see over a 2-week period, and the opening statements may end up being just sort of an afterthought.
You're totally right about them seeing a lot, because yesterday in the morning, they were hashing out some issues. Then they brought the jury in. Then they did opening statements. Then they went to lunch, and then we came back, and the state's first witness was Dominic Black, and then we heard from two other witnesses all in that day. I mean,
Mm-hmm.
that's a lot in a day. And Dominic Black was the state's first witness. He, according to the state, he's a friend of Kyle Rittenhouse, and he is accused, faces felony charges for purchasing the alleged weapon in this case. Did you get to see any of his testimony?
I saw a little bit, yeah. So he's represented by attorney Tony Cotton, who is a very capable guy, and Tony is obviously guiding him through the process. And it looks like Black was cooperative with the state. It didn't come out during the testimony, but I would not be surprised to find that ultimately Black's strategy is to try to cut some kind of a deal and say, oh, and by the way, I was cooperative with the government, so I should be given some credit for that in some regard. So we'll see how that pans out. That's another story for another day.
Yeah, that's something Attorney Mark Richards brought up. He
Mm-hmm.
said you've been having conversations, and then there was one question that I thought maybe took Richards by surprise when he says, "Did Attorney Binger ever tell you that you could contact me?" And he said no, or it was something along those lines. Like there was like he had not had contact with Attorney Richards or
Mm-hmm.
but
I think the reality though is he's been represented by a lawyer the entire time, and once someone is represented by a lawyer, somebody like Attorney Richards can't just call the witness and say, "Hey, I want to talk to you about the case." They have to go through the lawyer. So that's why Tony Cotton would have been doing the negotiating with the prosecutor over whether Black was going to testify, and if so, whether he was going to receive some reward for his testimony.
And the other thing I noticed with Black is we kind of got a little more of the timeline of their friendship. Just sort of, how Black says he was dating Kyle's sister, and then they became friends, and then they would go up north together to kind of target shoot, and then Black said that he had an AR-15, and that's how he believes Kyle Rittenhouse became interested in getting one for his own.
Mm-hmm.
Then we kind of got the story behind a Facebook photo of him holding a weapon, and that was up north, and then we kind of got a little more of the timeline of the day. So it just was a little fuller picture of a little bit of that friendship and a little bit of that day, it seemed. So that was an interesting, I think it was kind of interesting to hear that was their first witness.
Well, I think they wanted to put the gun in Kyle's hand, and they wanted to tell the story about how it is he got the gun. So it sort of makes sense that that's what they would start with.
And then they showed them, actually. They pulled them out of evidence. I didn't even notice there were these white evidence boxes. And then all of a sudden they have a detective bring it up to the stand to show Dominic Black. So
and have them identify it. Yeah. I mean, if you think about it, every single charge or all the major charges have a while armed enhancer. So one of the things the prosecutor has to prove beyond a reasonable doubt is Rittenhouse had a firearm. And it sounds obvious from the videos and so forth that he had one, but if you can actually bring it into the courtroom and show it to the jurors, it's a more dramatic and more effective way to establish that element of the crime.
Then after Dominic Black, they had an FBI agent testify. So there was no audio and no video of that. I left the courtroom at that point just to kind of work on stuff for the 5 o'clock news. So I didn't get to see him, but I did hear from the pool reporter there was an objection to parts of his testimony. So they may go, or I'm not sure who the agent was, but they may go back to that agent. And then they got Corey Washington, who is a social media influencer from Kenosha, on the stand, who was live streaming that night. And so they ran out of time with him, started back up with him this morning. And then after that, they put Detective Martin Howard on the stand, and he today I think he was more there, it seemed, just to kind of uh walk through some of the videos that he was pulling from that night. Did you get
That
to
was
see
my
it?
impression.
Yeah.
Yeah, my impression was that they used him as a conduit to get the video in, and it sounds like he collected a lot of it from social media websites, or tipsters had sent in things to him, so they used him to just sort of bring in the video.
Yeah. And the pool reporter who was in the courtroom said, there was a lot of video we watched today. Some
Hmm.
of it, I thought I had seen most of it, but there was some of it I thought, wow, I hadn't seen that one. I hadn't seen that one. It was very graphic, a lot of profanity. I mean, you almost, I mean, many of coworkers of mine who were out there that night, and then I was out there the night before. I mean, you kind of forget how chaotic it was, and watching some of this back, you kind of are like, wow, I that was kind of crazy that night.
It really was. To
Yeah,
see
and
to see
so,
that in the middle of the street, yeah, it was quite a scene.
and you know what, the jury, there were a lot of concerns that potential jurors had raised to the judge and to the attorneys during selection, that they have a lot of consternation about being on this jury, just, you know with friends and family, reaction to the verdict, just the pressure of it.
Hmm.
And a lot and, there was a number of them who would raise their hands saying, if the attorneys asked them, do you know somebody who had property damage, or did you know somebody who was out demonstrating that night, or it just kind of questions like that, and several would raise their hands. So this, you could tell, like, the scope, kind of the size of the Kenosha, and how this affects. There were people on the jury that this could have affected in some degree, who like, who were living in town that night.
Sure.
And so the pool reporter said that the jury was riveted. Their eyes were glued to the screen, watching these videos. And then they kind of took a break around 4:30. Uh, there was one thing I was going to ask, and it was something Attorney Mark Richards brought up on cross examination of this detective. He asked about a search warrant of Gage Grosskreuz's phone and issues with Marcy's law, and that's a victim's rights law. But would you be able to shed any light on that? I don't know if you heard that part of the
I did
testimony.
not hear that part of the testimony, but obviously Marcy's law is the victims' rights legislation or constitutional amendment in Wisconsin, and it affords certain protections to people who are deemed to be victims. So it may be that there's information that wasn't provided to the defense, and Richards was attempting to highlight that the manner in which he was being treated once he was deemed to be a victim.
Yeah. Um,
But yeah,
I
to back
oh, go
up a little bit, you're talking about how riveted some of the jurors were. I did watch part of one of the videos that was shown, and it was the moment that the second homicide occurred in the middle of the street. You can see the gun smoke, you can hear the pop of the firearms, and for even experienced people, for police officers, lawyers, judges who are involved in these things on a regular basis, to see someone basically being executed in the middle of an American street is a disturbing image. And I'm sure that these lay people sitting in the jury box were truly disturbed by it, even if they've seen the video previously.
I can imagine, because we were watching it through the screens down in the media room, and it was hard to tear your eyes away. And I mean, people, you can hear people screaming. Uh,
Mm-hmm.
you can hear how chaotic it was. The putting them all together. I've in my experience of just reporting on this case, we watched the individual videos, but the
Mm-hmm.
span of time that this happened in was mere minutes. I mean, and then and based on some of the other videos that didn't show the shooting, but you could hear it in the background. It's loud, and it does kind of, it's a frightening sound.
Yeah, and the sound combined with all the chaos going on around it, it was a disturbing scene, and for anybody who was down there, it must have been terrifying.
Um, I think so. Tomorrow we don't know. I don't know who's going to be coming to the witness stand. I'm assuming, it'll be more investigators, people from that night. We just kind of have to see in what order. But I would assume, I would also think that's probably not the last we're going to see of those videos, because we're probably going to hear from people who were in those videos as well. Joshua Zeminski, Gage Grosskreutz, and a few others. One last thing. So in opening statements, Mark Richards said this in a way that hinted at this, but he said, you'll not only hear from Mr. Rittenhouse, you'll also hear from da 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 da.
Mm-hmm.
So how should we take that? Is that an indication we may hear from the defendant?
I mean, generally speaking, lawyers will be very careful about committing their client to testifying unless they're really certain they're going to do it, because once you get up there and promise, hey, you're going to hear from the defendant, it's sort of a big deal. They have the right to remain silent, and they're going to waive that right. They're going to get on the witness stand. They're going to subject themselves to cross-examination. So if he said that, I'm pretty confident he's going to follow through with it, and Rittenhouse will get on the stand. And it makes sense that Rittenhouse would get on the stand, because the ultimate question is what was in Rittenhouse's mind at the time that he took the action that he took. And if he reasonably believed that the only option he had was to use deadly force, that's what helps him establish self-defense. So you can talk about video, you can have other witnesses testify all day long, but at the end of the day, the real issue is what was in his head at the time that he did this. So I'm not surprised to hear that he's going to testify. He has made a statement already to law enforcement when he turned himself in and didn't have a lawyer. He waived his right to, he waived his Miranda rights at that point, and he made a statement to police. So from the beginning, he has basically claimed that he was defending himself. There may be a more polished version of the statement once he gets on the witness stand and he's subject to cross-examination. But I'm not surprised that's the tack that they're going to take.
We'll have to see. With that, I'm going to let you go for the evening. Thank you so much for joining me again. It's such a pleasure to talk and hash this out and just talk about what we saw during the day, because there's a lot that goes on, and people can join in and ask questions and listen to your expertise as well. So I think that's it. And have a good night.
Great. We'll talk soon.
Thanks.